Good day to all. So, our topic for today is about alternative circumstances. So, bear in mind that aside from those justifying, exempting circumstances which would exonerate or justify a criminal act of a person, hence he cannot be made criminally liable, and those that may either aggravate or mitigate one's criminal liability, we have other circumstances under Chapter 5 which would be taken on a case to case basis. So, in the alternative circumstance, we have relationship, intoxication, and degree of instruction and education of the offender. These are taken into consideration either aggravating or mitigating circumstances to the nature and effects of the crime and other conditions attending its commission. So let's start with relationship. When shall this be aggravating? When shall this be mitigating? And what relationship or whose relationship are we referring to? The alternative circumstance of relationship shall be taken into account when the offended party is the spouse, ascendant, descendant, or legitimate natural or adopted brother or sister, or relative by affinity in the same degree of the offender. So who are these relative by affinity that we are referring to here in relationship? So you have there your parent-in-law, son-in-law, brother-in-law, sister-in-law. So those actually referring to the other relatives mentioned in relationship, only that they are by affinity and not by blood. To be specific, the other relatives that is covered are those relationship of a stepfather or stepmother and that of a stepson or stepdaughter. It could also be the adopted parent or adopted child. So to illustrate as to when shall it be mitigating or when shall it be aggravating. Generally, relationship is mitigating in crimes against property, taking into consideration the provisions of Article 332. In Article 332 of the Revised Penal Code, it provides that no criminal, but only civil liability shall result from the commission of the crime of theft, swindling, or malicious mischief committed or caused mutually by spouse, ascendants, and descendants, or relatives by affinity in the same line, brothers and sisters, and brothers-in-law or sister-in-law if living together. So the justification that relationship is mitigating in crimes against property is this provision in Article 332. A aimed a knife and took the watch of his father and pawned the same without the consent of his father. So basically, there is a crime committed here by the son as against the father. Now, the crime committed is robbery, which is a crime against property. Why robbery? Because the taking here was done with intimidation on the part of the accused to the private complainant. So, since robbery is a crime against property, it is mitigating. On the other hand, it shall be considered as aggravating in crimes against persons where the offended party is a relative of higher degree than the offender. Now, when we talk about degree, your relationship to your father, that is a degree higher, your relationship to your grandparents shall be 2 degrees higher. So that is how you count the degree of your relationship. That is from our civil laws. When the offender and the offended party are relatives of the same level, because basically the previous one, that is very clear, that if relative of the higher degree is the offended party, then it is aggravating. Now, if they are of the same level, meaning to say brother or sister, brother-in-law, sister-in-law, half-brother, or an adopted brother, same rule, okay? Either higher or same level. But if the crime against person is any of the serious physical injury, even if the offended party is a descendant, as a rule, it is aggravating. Now, other than serious physical injury, meaning to say, less serious or slight physical injury, ordinary rules apply. What ordinary rules are we referring to? It is only aggravating if the offended party is of higher degree or of the same level. Aside from those that have been mentioned already, when the crime against a person is homicide or murder, relationship is aggravating even if the victim of the crime is a relative of lower degree. Okay? Same with that of serious physical injury. Relationship is neither mitigating nor aggravating when relationship is an element of the crime. So what we are referring to here, if the crime is parricide, so relationship would not be considered as mitigating or aggravating anymore because it is basically the reason why a person is charged for parricide because of his or her relationship to the offended party. In crimes against chastity, so you have there seduction, abduction, or acts of lasciviousness. These are the crimes against chastity. Relationship is always aggravating. Example, A killed his stepdaughter with the use of a knife. Take note, the crime committed is murder or homicide as the case may be. So relationship here is aggravating but in parricide as the relationship here is aggravating. So either murder or homicide is the crime committed by the accused. Why not parricide? Because their relationship is not by blood. Their relationship is not by blood, hence murder or homicide only. The relationship here can be considered as an aggravating against the accused. It is not considered an element of the crime because the charge is only homicide or murder as the case may be, depending on how the same was committed by the accused, whether it is qualified or not. So hence the distinction. So that is all about relationship. How about intoxication? When shall intoxication be taken into consideration as a mitigating circumstances? When shall it be considered as aggravating? So we have here the answers or will serve as your guide to those particular questions. It shall be considered as mitigating if the offender has committed the felony in a state of intoxication, if the same is not habitual, and not subsequent to the plan to commit a felony, meaning to say, you're being intoxicated at the time of the commission of the offense. When we say not habitual, meaning to say you are not really a drunkard. And when we say not subsequent to the plan, meaning to say you might have that in mind, committing the crime, but then it was not done after you have planned to commit the crime, meaning to say it's just unintentional. or it just so happened, that would be mitigating. Reason? Because the intoxication here may have diminished your will, may have diminished your intelligence as far as your evaluation as to right from wrong is concerned. So that is the reason why the same is considered to be mitigating. So your penalty shall be imposed in the minimum period because of that intoxication that disturb or blur your reason. On the other hand, it shall be considered as aggravating when the intoxication is habitual or intentional. When we say habitual, meaning to say you are really a drunkard. You are always in the state of intoxication, meaning to say the law says it, that if you are a drunkard, you are really prone to committing crimes. What do we mean by intentional or subsequent to the plan to commit a felony? It would mean that you conceive the commission of a plan. And to boost your confidence in committing the felony, you took some intoxicating liquor, thereby boosting your confidence in the commission, meaning to say it was really intentional on your part in taking such intoxicated liquor. So in that particular scenario, that intoxication there is considered to be aggravating. So to reiterate the rules that we have to follow in intoxication, for an accused to be entitled to the mitigating circumstance of intoxication, it must be shown that at the time of the commission of the criminal act, he has taken such quantity of alcoholic drinks as to blur his reason and deprive him of certain degree of control over himself. And that such intoxication is not habitual or subsequent to the plan to commit a felony. To illustrate, A was charged for less serious physical injury. It would appear that prior to boxing the victim, his friends invited him to a drinking spree which he is not used to. The intoxication must be of such amount as to blur his reason and self-control. So in this particular illustration, this shows why intoxication here should be considered as mitigating. On the other hand, if the accused is a known drunkard, it is always aggravating. A habitual drunkard is one given to intoxication by excessive use of intoxicating drinks. The habit should be actual and confirmed, but it is not necessary that it be continuous or by daily occurrence. People versus amin-amin. To illustrate, A has been drinking with his barcadas regularly in the store of B. When the night was getting dark, B refused to give them more bottles of intoxicating liquor, which angered A and hacked B with his bolo, causing the latter's death. Now, take note that the regular drinking of A here qualifies him to be a drunkard. So that would mean that intoxication here shall be aggravating to the crime he commits. Compare. A decided to kill B. A planned to commit the crime by preparing the means to carry it out. Meaning to say, he has decided to commit a crime and he prepared for it by preparing the means that he is going to use for each accomplishment. When he was ready to kill, he drank a glass of wine, and when already intoxicated, he looked for B and killed him. Is intoxication aggravating or mitigating? Now, take note that in this particular set of facts, you have there the conception of committing a felony by A. When he was done, he intentionally intoxicated himself. So basically, that would be aggravating. Reason again, because the same was after the no, it was after or subsequent to the plan to commit the crime. So, aggravating. To reiterate on the two, intoxication as a mitigating circumstance finds its reason in the fact that when a person is under the influence of liquor, his exercise of willpower is impaired. Intoxication as aggravating when it is intentional. The reason is that the offender resorted to it in order to bolster his courage to commit a crime. It is aggravating when intoxication is habitual because of the constant use of intoxicating liquor lessens the individual resistance to evil thoughts and undermines the willpower, making himself a potential evildoer against whose activities society has the right for its own protection to impose a more severe penalty. Okay, so that is how intoxication shall be taken into consideration, shall be evaluated so that it may be considered as aggravating or mitigating. Then you have their degree of instruction and education of the offender. Generally, low degree of instruction and education or lack of it is generally mitigating. High degree is generally aggravating when the offender avails himself of his learning in committing the crime. So you have their decided cases already by the Supreme Court. In People versus Mang Sant, the court ruled that lack of instruction cannot be taken into account where the defendant admitted that he studied in the first grade in a public elementary school. Article 15 only applied to him who really has not received any instruction. But the accused lacks education and instruction if he did not finish even first grade in elementary. People versus Limaco. And in People versus Bernardo, must be proved positively and directly and cannot be based merely on inference. So that is degree of instruction and education as a mitigating circumstance. To illustrate such rule, low degree or lack of instruction is mitigating in all crimes, except in crimes against property such as estafa, theft, or robbery, or arson. Why is that not considered mitigating? Even if the accused has low degree of instruction or education. Because in these stated crimes, enumerated crimes against property, that entails planning. So if that entails planning, that would negate lack of instruction or education. But in US versus Mackey, lack of instruction was mitigating in theft, despite the fact that theft here is included in the enumeration, because in this particular case, the accused here is a member of an uncivilized tribe of Igorots or in Igorot land. And this is actually the only case where lack of instruction was considered mitigating. Okay, you have the general rule, not mitigating. Okay, not mitigating. But here in Maki, it was considered to be mitigating. Also in crimes against chastity. So what is chastity again? The crimes included seduction, abduction, acts of lasciviousness. So that does not need high degree or low degree of instruction for one to commit a crime, because we know for a fact that we have to respect other people. We know for a fact that we don't violate anyone. So in crimes against chastity, even if the accused has low degree of instruction or lack of instruction, that is not considered to be mitigating. Illustration on high degree as aggravating. So particular or practical example would be that of a lawyer. It is aggravating if he commits estafa because basically he abused his education and learning. That's why he was able to deceive someone, defraud someone to part with his money or goods. Also, a doctor who, using his knowledge, prepared a certain kind of poison to kill his victim in such a way as to avoid detection, may be considered aggravating as having taken advantage of his high degree of instruction and education. In this particular scenario, what it shows us is that a poison, which may be composed of medicines, to be precise, the doctor who has high knowledge about these medicines, he prepared a poison in order to kill the victim. In short, high degree of instruction is aggravating when the offender availed himself or took advantage of it in committing the crime. So I hope with those practical illustration, it would be easier for you to evaluate when shall relationship, intoxication, low degree or high degree of education be considered mitigating, or when shall it be aggravating. Let me end with this lecture that these words from Thomas Edison. Our greatest weakness lies in giving up. The most certain way to succeed is always to try just one more time. Okay? No matter how hard it is, no matter how difficult it is, a challenge should always be a stepping stone to your success. With that, thank you for your time and good luck to your quiz.